September 15th, 2020, shortly after midnight, Jason Fox sent two messages to his former roommate. The first, 22 Jurgens Road, and the second, just in case anything happens to me. The next day, he was reported missing. 22 Jurgens Road is a lightly forested 50-acre property with multiple buildings, a wedding venue, a shop with a couple apartments, and a small home. Many people lived on the property, including Claude Merritt, Riley Hillstead, Matthew Radaz Freeman, and his wife, Amanda Pearson. On September 17th, law enforcement went to the property looking for Fox. Merritt told officers he hadn't seen Fox in a couple weeks. Investigators found that Fox's cell phone had pinged at the home the evening he went missing. They returned to the property and Merritt changed his story. He stated Fox was at the property that night but was escorted off after a conflict and drove away. On October 3rd, the property was searched and Fox's body was found buried in a wooded area. His hands had been tied behind his back and his skull was fractured. When questioned, Merritt told officers it was Radaz Freeman and Hillstead that beat Fox. He was scared for his life. He said they led Fox outside and he had been told to clean up the blood in the shop. In the morning, he was told of Fox's fate. In court, Fox was found guilty of multiple charges. Now he appeals his conviction, arguing the state violated his right against self-incrimination and that they also violated double jeopardy by including the convictions for counts 2 and 3 in his judgment. Let's take a look at the arguments.
May it please the court, Casey Granis on behalf of Claude Merritt. Merritt's prosecution and conviction for violating the notification statute violated his Fifth Amendment right against self-incrimination. In a case where a person is alleged to have murdered someone, that same person cannot be forced to incriminate himself by telling authorities where the victim is located. Merritt was penalized for not incriminating himself in Mr. Fox's murder.
How would he be? How would he tend to incriminate himself? This is one of the questions. At least I thought oral argument was necessary. How would he tend to incriminate himself if he somehow anonymously notified either the coroner or the sheriff's office of where the body was located?
So two responses to that question, Your Honor. One is that the question presumes that anonymity is possible in a case like this, or practically possible. As pointed out in the briefing, the notification statute requires that notification be given in the most expeditious manner possible. And that has implications for this whole idea of anonymity. He's got to either, someone in this Mr. Merritt's position either has to show up personally and talk to the authorities, or communicate with them, via phone, computer, email, whatever, but those things are traceable. So either way, I mean, there's this, the idea that it's possible or realistically possible to avoid, or rather to maintain anonymity in a situation like this, it just doesn't seem realistic.
Even if it was, you were able to anonymously somehow communicate the information, so no one knows it was you, and then you're charged. But you communicated it, but it was anonymous. So what happens there?
In other words, how do you prove that?
How do you prove that I complied with the statute, but I did it anonymously?
And
so
also
no
get out of the murder charge.
Yeah, I mean, it creates kind of an absurd scenario. Turning to the facts of Mr. Merritt's case, I mean, he brings an as-applied challenge to the application of the statute to his conduct. And, the fact is, under the evidence presented, he didn't notify anybody. But when we're looking at, was there a realistic threat of self-incrimination here? We look at the facts of his case. I mean, the evidence showed that Mr. Merritt was involved. He's convicted of Mr. Fox's murder. The evidence showed that he was the one, at least according to one witness's testimony, that he was the one who, participated in beating Mr. Fox up, brought him to the edge of the grave, tied up, and then was told shortly thereafter by one of the other participants that that was Mr. Fox's, that's where he was buried. So if Mr. Merritt had complied with this statute and notified the authorities, in the most expeditious manner possible. That meant even before an investigation was launched and identified Mr. Merritt as a suspect, even before any official proceeding was commenced against him. The statute required him to affirmatively seek out the authorities and say, hey, I know about a dead body. Here it is. And then, of course, realistically, what's going to happen after that? Yes, an investigation is going to be launched. Questions are going to be asked. Things are going to be followed up on. How do you know this? What's the basis of your knowledge? Of course, in the end, he didn't comply with that statute, hence the conviction. So he was.
Mr. Granis, let me ask you a question. And it kind of goes towards, the difference between a facial challenge and an as-applied challenge. But I can think of a way to comply with the statute and protect yourself, and that is to go to an attorney and say, hey, I know where there's a dead body. Would you notify law enforcement? And so then the attorney goes in, and obviously that conversation is covered by confidentiality, and yet it's anonymous. So given that I can think of a way to comply with the statute without impacting a constitutional right, does that affect our analysis of the constitutional, does that affect our constitutional analysis?
Well, as your question indicated, Your Honor, it would affect the constitutional analysis if Mr. Merritt had brought a facial challenge to the statute. I can agree that there could be circumstances in which this statute could be complied with without incriminating yourself. Of course, in Mr. Merritt's case, to point out the obvious, he didn't go to an attorney to have the attorney act as some sort of proxy in revealing this information. If he had done so, yeah, one, there probably would not have been a prosecution. The two, we'd have quite.
But wouldn't you still have the problem that nobody would know that he in fact did comply with the statute, and so he's charged with this misdemeanor, and there's no way he can defend against this while he's also charged with murder? In other words, he can't step forward and say, oh, I was the guy who anonymously gave you the information, without sabotaging his defense that he didn't commit the murder.
Yeah, that's a good point, Your Honor. If it's a situation where, again, it's an anonymous report, then he is put in a no-win situation when it comes to the prosecution.
And I think there's some U.S. Supreme Court case law on subpoenas, on whether or not someone can be subpoenaed to bring in information that would tend to be inculpatory to the grand jury. And the U.S. Supreme Court says you can't compel, even though the person is not required to say a thing, the mere act of bringing in documents would authenticate that they're tied to someone, and you can't require someone to do that unless they're granted full use immunity, and I think transactional immunity, not just, well, maybe not transactional immunity, but you can't draw any, it would have to be a grant of full immunity from the entire act. And I don't know how a statute would be able to grant immunity, but certainly this statute's not granting immunity to that act of disclosure.
Yes, Your Honor. As mentioned in the briefing, the lack of immunity here is a problem. The statute doesn't provide for it. The prosecutor didn't give it in this case. So without this immunity that is protects against the substantial penalty being lodged against the person who doesn't comply with it, that's why the self-incrimination error rears its ugly head in this case.
Yeah, and it's similar to the grand jury subpoena case. You can't be held in contempt of court unless you're offered immunity. So unless there's some sort of offer of immunity there, you can't be penalized for not complying with the subpoena. So it seems like here, unless there was an offer of immunity, you can't be penalized for not essentially, it's akin to a subpoena coming forth with information.
Yes, I agree with that analysis, Your Honor. And I could.
This is the time where you realize you win on that issue.
Yeah.
And, if you want to keep on talking about it, you may, but it's not going to get any better. Feel free to talk about other issues, but really this is the issue that I saw that warranted oral argument. If you want to rest on this, fine, and reserve, that's fine. But if you want to talk about other issues, you may.
Just quickly, Your Honor, I'll wrap up here. I'd just like to step back for a moment and point out how weird this charge is. I've looked, I can't find another case where a prosecutor's office in this state has ever brought this charge against the alleged murderer. Really, the state just went too far and throwing everything it could possibly conceive of at Mr. Merritt. At any
They've
rate,
got discretion to do that.
yeah. At any rate, this notification conviction needs to be thrown out. Thank you.
Thank you.
Mr. Granis.
Mr. Pierce, you have a hostile audience in front of you.
Your Honor, it's a very interesting discussion. May it please the court, Brett Pierce on behalf of Pend Oreille County, especially through WAPA, I suppose you would say. I suppose I may as well just get right to the questions Your Honor's asked, because those are the questions you wanted answered. First, Judge Lawrence, for your question about whether or not the statute could be complied with anonymously being a good inquiry here, I would look at what the statute actually requires to be, what information the statute actually requires to be given to, I don't want to say the authorities, because it's not just law enforcement, it could be the medical examiner or the coroner. The only thing the statute requires is the location and the existence of a known body. It doesn't say what state is the body in, how do you know about the body, what's your name? None of that information is required by the statute. So I think this is a bit distinct from a situation where the statute is asking for deliberately incriminating information. It's more akin, I think, to the hit and run statutes. A lot of hit and runs, not all, most are just accidents, but some are caused by criminal activity like DUI, reckless driving, whatever you have. And we know that both of our Supreme Courts have said, if you've got a general duty to give over your information, even if that has collateral consequences, even if that information...
Let's say though that he identifies himself to the coroner.
True, not
okay. So that's scenario one. Identifies himself, provides the general information. They find the body, and police ask him, "Well, how'd you come upon this body?" I mean, it was fairly well hidden, the body, and it would tend to incriminate him the fact that he knows it so quickly after the murder, because by October 4th, I believe the police did know where the body was, and so this person would have to come forward before October 4th with this information and not to be charged with this particular violation. And so to report to the police or the coroner so quickly after the body's buried, it would tend to implicate him, I think, but tell me if I'm wrong.
Under that specific fact scenario, yes, Your Honor. If somebody went to police and said, "Hey, I'm Claude Merritt. I know of this body. It's on my friend's farm. We murdered him over a drug debt."
Oh, don't say you murdered. That's a little bit too much.
That might be too much incrimination, but those extra statements aren't actually compelled by statute. So that would be more akin to spontaneous statements that Mr. Merritt did say, and he could. And I'm certain under a lot of scenarios, someone who's trying to comply with the statute might volunteer more information than is required by the statute. Well, that's not an issue.
They don't even need to volunteer the information, but if the police say, "Well, how did you come across this?" and the guy refuses to answer, that kind of tends to incriminate him too.
Right. If the only way you know there's a dead body is because you caused the dead body, then connect the dots.
Sure. I don't think that the state would be permitted to use that as an adverse inference.
Not as an adverse inference, but I guess that it still tends to incriminate you, because then the investigation starts focusing on you, because you have knowledge that somebody buried this body because you know where it was. And if you know who buried it, then you're protecting somebody, which means that you were somehow part of this too. It just seems to tend to incriminate. It doesn't, it's not open and shut, but it does tend to incriminate at that point.
Which is why, and I'm looking at the Webster-Hubbell case, and there's a few others from the U.S. Supreme Court, that unless you're given immunity, just the act of producing documents, you don't have to say a thing about them, but just the act of you physically producing documents, and those documents contain incriminating evidence, ties you to them. So the mere fact of, this body is located so-and-so place, that ties you to the body through your own testimonial act, even of coming forward. So I think, that's the concern. Hit and run's a little bit different because all you're doing is stopping and giving your name, right? You don't have to say, "I was in the accident" or anything like that. You may want to, but you don't have to comply with the statute. So that seems to be a little bit different. Also, the passage of time to me is a little bit different from sort of right in the moment what you need to do versus, the passage of time of connecting yourself to an ongoing crime, essentially. So, I'm worried about that, and the fact that it's not directly incriminating. It certainly didn't work in the grand jury context. The Supreme Court has said the fact that you're not asked to answer a single question, just turn over documents, you can't be forced to do it unless you're given immunity.
I agree, Your Honor, but I think my answer to that would be, and this kind of ties into Mr. Merritt's claim about the Flannery case. When a court action or court order is requiring specific compliance from a specific person who's already in a court proceeding, the analysis changes a little bit. At that point, it's no longer just a general duty imposed on the entire public. It is your subject to this court's jurisdiction. We need you to turn over these documents. That's not a general duty, but it does tend to implicate the buyer's, dicta, you would say, about whether or not the statute or order is targeting a select small group of people whose activities are inherently criminal. When you're at the grand jury stage, you're part of that select group of inherently potentially criminal activities. So that's how I would distinguish the grand jury situation. And I think that's why Flannery also should be distinguished. I'm not sure, it sounds like Your Honors are going to get that far, but in Flannery, in order to comply with the firearms surrender statute, somebody who's already been accused of a DV crime has to submit a declaration to court saying, I don't have any firearms, or I'm not going to comply with your order. At that point, they're a highly selected class of people. And also, the only purpose of that declaration is to monitor compliance with the court order that had already been issued, commanding them to give up the firearms. So even Flannery itself, which is Mr. Merritt's main source of authority, is distinguishable on that basis.
I'm trying to recall the exact phrase of the statute, but it does require a person to promptly report as soon as feasible. Words of that nature.
Most expeditious manner.
Most expeditious manner. In this particular case, I would submit that Mr. Merritt still would have violated the statute if he waited till October 3rd to report, because he knew that where the body was buried the day it was buried. Basically, when the police officers came out, it almost required him to divulge it right then. I mean, it just seems to me of what's required by the statute, especially because of this expeditious nature that you have to do it. With this as applied challenge, there's no way that Mr. Merritt could comply with that duty and not be a suspect, an immediate suspect here. And again, we've already talked about why he couldn't do it anonymously. But
well, we've also talked about why he could, Your Honor. Yes, assuming he identified himself and said, here's this body, it's on my friend's farm. Yeah, that's going to tend to incriminate him. But that's the difference between what's compelled by the statute and the scenarios we're trying to envision of how someone could or could not comply with the statute. The statute doesn't say identify yourself. It just says, where's it? Do you know of a body? Yes. Where is it?
Right, but then if you don't identify yourself and you're charged with the crime, how do you?
That's burden shifting, Your Honor. The defendant never. I imagine how this would actually play out in the courtroom if the state were to charge. If I knew the location of a body and I anonymously said, "There's a body, under my farm," and police came and arrested me, and I was charged with this statute, I wouldn't have to prove that it's not an affirmative defense. In other words, the affirmative defense is I thought somebody had given notice already. I don't have to prove that I didn't give it. I might if I wanted to, but the state couldn't prove that I didn't comply because the state has a notification. I mean, that's reasonable doubt, which is.
You're hoping that, people are communicating and that information is turned over. It just seems to me, okay, I don't know what that was. It seems to me if that's what the statute expected, the statute should say so, right? If the statute says, look, we have this procedure where people can be protected and turn over because what we're really after, but instead you're putting people in jeopardy, assuming huge sophistication that a person, it's going to privilege the wealthy because you're not going to get a public defender appointed to talk to you about, go notify law enforcement. You're going to have to be wealthy enough to pay for it, and you have to be sophisticated enough to do it. So it's penalizing people that are unsophisticated, not wealthy. It'd be different if the statute said, here's this procedure for how to do it, assuming people know how to read the statute, but at least there would be a procedure. But it shouldn't be, a person shouldn't be held liable for a crime because they can't figure out some sophisticated way to do this without incriminating themselves. The easy answer is this is forcing people in the clearest way possible to incriminate themselves. or be guilty of a misdemeanor.
It's only a misdemeanor. You got a big felony charge still there.
Right.
That's true, Your Honor. And I don't know, I'm sure the record sounds about the charging decisions, but it seems like this charge was just referred by the investigating officer, and I know they have authority to refer misdemeanors, so that's probably,
Right.
I'm assuming, because as Mr. Grant, there's not a lot of case law on this out here. I was surprised there was the Idaho case, in fact. And actually on that topic, and I'm not sure Your Honors will address the Idaho case, but that case, Akins, was, I think, decided on the same reasoning that it looks like this court's going to issue its decision on, which is it assumed that the statute could only be applied with by the person accused of violating the statute of giving additional information that wasn't actually required. I think the Akins case talked about, well, she would have had to explain why she transported to Spokane Valley and why it was in the lake. That information wasn't required by the Idaho statute. It was essentially the same thing, other than the fact that it required the information to go to law enforcement, which is another way that you would distinguish the statute.
Mhm.
I'm not sure that argument sounds like a good use of my time, however. The last point I'd like to make, just brief, well, actually, I take that back. This is important because there are other statutes with general duties that an overbroad ruling here might implicate those statutes in further cases. So I'd ask you to decide on the narrowest grounds possible, if possible. My last point is, I guess, I don't know how to phrase it, but the De Leon circumstance where the state compelled answers during jail booking about gang affiliation. And what our Supreme Court said is, giving those answers was fine. The problem, the Fifth Amendment violation occurs when the state then uses them in court.
Right.
I think there's a way to have the same type of outcome here, where if somebody were to, well, I mean, no one's going to want to place himself in jeopardy for murder. So
Right.
yeah. It was a long.
I'm not that good of a writer. None of us are that good of a writer to
Yeah.
figure out a way of doing that one.
I suppose felony murder is a bit more serious than a misdemeanor, not even a gross misdemeanor.
Right.
If your honors will just give me a moment to review my notes to make sure I didn't miss anything. I believe that's all the state has, Your Honor, unless you have further questions.
Thank you.
Following these arguments, the court affirmed in part, reversed in part, and remanded for resentencing. They concluded the trial court did violate the double jeopardy standard, and they also concluded that the application of the coroner notification statute violated Merritt's right against self-incrimination. Let me know what you think about this case, and please hit subscribe for new arguments every week.